Court of Elk County, Kansas, case entitled in the matter of the marriage of Antonio Manuel Perez Beal and Sidney Page Simon. It's case number 2023 DM 300003. I will note that Mr. Perez Beal appears along with his attorney of record, Ronald Wood. Sidney Simon appears separately from her attorney of record, Lauren Schuler. This matter comes before the court at this time for further proceedings. Counsel, this court had conducted a trial in this case, made rulings and orders which should be journalized by now. As far as I know, the court does not have a journal entry of judgment and decree of divorce submitted as of this point. I also note that Mr. Wood has moved to withdraw his counsel for the petitioner in this case, which has actually been objected to by the opposing party. So I'm going to start with Ms. Schuler and ask her, where are we at on this case?
Thank you, Your Honor. So did you receive my exhibits?
I did.
Okay. So I did draft a journal entry. The proposed journal entry is Exhibit A. I did supply the email that I sent the journal entry, showing that I sent the journal entry to counsel Mr. Wood. I sent that on Tuesday, May 13th. As you stated, we did have trial on May 7th. I did supply as well, which is reflected in the court filing, Exhibit C, which is Mr. Wood's objections. If you look at the objections, Your Honor, unfortunately, a majority of them are not actual legal objections. They are essentially requests to change your ruling. And I can go into further detail, but I would argue 80% of them are just requests to change your ruling. They're not actual legal objections. And I think that's where we're at a standstill. I was waiting on this hearing.
What about the other 20%?
I did make
corrections that are appropriate? As
I did make them.
Okay.
So specifically objection 1, 3, 7, 17, and partially 14 were all made. Missing a comma or referencing specifically the parties for joint legal custody. I did make those. But outside of that, the others are requests to modify your ruling. So I was waiting on this hearing to file a motion to settle the journal entry. So that's where we're at on the journal entry. I will wait to go over my objection to the motion if you would prefer that.
Buckle up, guys. Today we are going to dive into a courtroom showdown that's equal parts dramatic and unbelievable. Right from the start, we're introduced to a divorce case that already has tension written all over it. The man wants to ditch his lawyer and go solo against a judge who's not having it. You can feel the clash building, and this is only the opening scene.
All right, Mr. Wood, as far as the court's concerned, the court wants to settle this journal entry before allowing you to withdraw. I do understand the nature of your motion in this case, but I do note that on behalf of your client, you filed certain objections back on June 3 to the wording of the proposed journal entry of judgment and decree of divorce. Some of these cosmetic changes have been made, apparently. I understand that your client may not be 100% in agreement with the court's ultimate rulings in the case, but what this journal entry is intended to do is to simply document what the court did rule upon. So what's the problem here, Mr. Wood?
Well, Your Honor, I received from my client approximately 4 pages of changes that he wanted to make in the journal entry. I took those at the best I could and made those objections known to the court the best I could that would not be considered frivolous or completely not allowed in this type of a review of the journal entry. So I did what I could. And then once I did that, then I received wording from my client that he was did not approve of what I have objected to and wanted to know why I didn't use everything that he'd given to me as objections in the journal entry. So I did what I could to pare it down. What really concerned me, though, also is is that I filed that on June 3rd, but on his what he had sent back to me, objecting to what I'd sent, he'd started sending copies of that to the disciplinary administrator. And so that concerned me whenever the disciplinary administrator gets involved and indicates that, you know, she didn't want to be involved with that. So I understand the court's position on withdrawing, but I had to put forth the objections that my client in some manner objected to with the understanding that I think some of his objections really would be more of a motions for rehearing or motion for modification. And that's a little bit of a problem when people are using the internet or whatever they're using to come up with attempting to practice law. And so they don't understand the distinctions between those and the objections to the journal entry. You know, the journal entry is supposed to recite what this court had ordered. And it's not to be the objections to what the court had or whether you agreed or disagreed with what the court ordered. The journal entry is to reflect what the judge ordered. And whenever I get something saying, no, these are all the objections I have to the journal entry, and I'm sending these copies of all this to a disciplinary administrator, that concerns me that I've got someone, watching over my shoulder. He doesn't trust my abilities to do the work that I'm doing, doesn't understand with 46 years of experience that I know what I'm doing.
All right, guys, here's where things heat up. The father's lawyer makes his move to withdraw, laying out years of experience while explaining the impossible position he's been put in. He highlights his client's bizarre demands, even mentioning complaints filed with a disciplinary board. This isn't just legal strategy, it's a professional breaking point, and the judge isn't letting him walk away without a fight.
But if he and I cannot communicate, if he continues to think that I'm not doing a job for him, then I just figured I had to withdraw, Your Honor.
All right. Ms. Schooler, I'm going to go back to you for a moment. I trust that there's been some personal communication between you and Mr. Wood in an attempt to try to reconcile differences on the wording of the journal entry, perhaps a recent phone conversation or email chain or something?
I did call Mr. Wood. I did let him know I was going to have to object because we were still in the process of working out this journal entry. You did order for some documentation to be provided to me by petitioner in regards to picking a vehicle. So I said, hey, get me that. We did not go into the journal entry as much. I did let him know, hey, I made some of the cosmetic corrections, but your objections or your client's objections are, again, more so for reconsideration, and I'm not going to make those changes. And that was after our Exhibit D, the email, including me and Mr. Wood with the disciplinary administrator, where Mr. Presbeal says he is going to file an ethics complaint against me. So not as much as I'm sure the court would prefer, but obviously with this email coming out, I believe Mr. Wood was trying to be as cautious as he could due to the situation.
All right. So the first issue before the court is settlement of the wording of the journal entry in this case. And in doing so, I'm going to try to systematically go through here and determine, is there a legitimate objection to the wording used by Ms. Schooler in what I see as, and I want to make sure everyone's on the same page as to what I'm referring to. In my exhibit notebook, it's Exhibit A, which is what I believe is Ms. Schooler's most recent attempt to draft an appropriate journal entry of judgment and decree of divorce. Is that correct?
Yes, it is, Your Honor. All
right. Obviously, the comma in number 1 has been resolved. Petitioner objects to the court's finding, and the petitioner will not respect the bond of the respondent. Oh, to the extent, apparently, that the petitioner will not respect the bond of the respondent in this matter. If that's consistent with a ruling from the bench, and I think it is, then that's not objectionable.
May I make a statement?
Mr. Perez Beal?
Yes, sir.
So-
That's me.
What's your statement?
My concern here is several things in the journal entry are not written how the court ordered. I have recently filed for a transcript request for the judgment in this case. I've paid for that and I have a receipt for it. And a lot of the wording affects the legality of the court's judgment. And when it comes to getting involved with disciplinary administer, I done that because Mr. Woods failed to address our son getting bit by a dog while in his mother's care, failed to address Sydney not showing up for
Okay, we're
exchanges
getting off the
of
path
order
here.
twice.
We're
No,
getting,
sir, we're not.
okay. All right, regarding number 2, the court will overrule any objection to this finding. Mr. Simon's actions in, as I recall, taking possession of the child at a bus stop, that alone gives this court pause and some reason to make a finding that the court has concern that Mr. Perez Beal will not respect the bond of this child with his mother.
That was during my
And there are other
parenting
reasons. However, the court finds that the objection is overruled as to number 2. Number 3 apparently has been corrected. As the court recalls, there was a protection from abuse case previously between these parties. The court finds that even though Mr. Perez Beal may deny that there was ever any abuse by him, court does find that that's an appropriate finding for the court to make. And the court will
Point of
overrule the
order.
objection to number 4. The court also finds that there has been difficulty between these parties based on the evidence to effectively communicate regarding setting a parenting plan or deciding many important matters concerning this child. So the court does
I'm
find that there's
submitting all of
evidence
our
in the
text
record.
messages.
All right, if you interrupt one more time, Mr. Perez Beal, we're going to mute you or take you out of the meeting completely.
Yes, sir.
At this point, the father jumps in, and you can tell he's desperate. He insists that the journal entry doesn't reflect what was ordered, pointing to errors and even dragging in claims about his child's safety. His tone is combative, and instead of sticking to the legal issues, he spirals into accusations. It's a moment that shows us he's not just fighting the case, he's fighting the system and even his own counsel.
So the court does find that there's evidence in the record to support that finding of number 5. Objection number 6, objecting to paragraph 13 in the school district should be USD 232.
Your Honor, just so you don't have to pull up the, Google it, USD 232 is DeSoto, Kansas, which is up towards Lenexa.
282.
All right, so number 13.
A lot of the
Schools,
objections-
why is that a problem?
A lot of the objections he made are not what I requested, and I'm getting ready to submit that,
All right.
what I have requested to him.
Okay, I think the children do attend West Elk schools, correct?
Yes.
Yes, sir.
Okay, so what's improper about 13?
He has manipulated my
objection.
objection request.
Okay. I don't think we need to put the USD number in there. I think the term West Elk schools is specific enough. I'll overrule any objection to 13. Number 7 apparently has been corrected, Ms. Schooler.
Yes, it has been.
Paragraph 26.
Yes, I did make that correction.
All right. That appears to be consistent with the orders and rulings of the court as it currently reads. Objection 8. Is there some dispute about the amount of child support to be entered into the record here?
Yes,
Yeah.
sir. There's been 3 child support worksheets entered on this without a chance for me to do taxes and submit financial records. And her most recent one states it was filed in I believe June 13th
Okay, well,
or May 13th.
okay, wait a minute. Let's back up. Mr. Wood indicated in his objection that I ruled from the bench that I was specifically adopting a particular child support worksheet that called for an amount of $1,383. So why wouldn't that be appropriate, Ms. Schooler?
Your Honor, because you did not adopt a specific worksheet, we imputed Mr. Perez-Beal's income at $58,000, I think $230. I might be off on the last few dollars, but he was imputed. Correct. And I had to make the tax adjustments, so there was no actual worksheet adopted because I had to make a change. But he was imputed by you, or his income was ruled upon that it needed to be imputed. So the February 12th worksheet does not have the imputed income because we were never provided that information.
There was never no paperwork filed to omit the previous child support worksheets that were submitted with a file stamp.
Now watch closely. This is a power shift. The judge pushes back hard, overruling objections and laying down an unmistakable warning. Interrupt again, and you're out. This is no longer just a family case. It's a masterclass in courtroom control. The father has crossed a line, and the judge makes it clear who owns a gavel. The tension rises, but the judge stays firm, steady, and immovable.
One of them by Miss Simon herself with a self-litigant form that she submitted with it. And, Your Honor, I'm getting ready to file a motion and lay out a lot of things that have gone on here that I believe Miss Schooler and Mr. Woods are discussing and kind of having backroom conversations. Mr. Woods' motion to withdraw on our inability to see eye to eye on this is false. I use a phone recorder, and Mr. Woods previously told me, I believe it was the 10th, that he demanded $7,000, and if I didn't pay, he was going to withdraw.
All right.
So,
Okay,
extortion.
I'm really just focusing on the child support worksheet, one issue at a time. I don't see your proposed worksheet, which calls for that amount. Ms. Schooler, it doesn't appear to be an attachment to your journal entry.
What about the respondent file?
Okay, Mr. Perez-Beal, be quiet for a moment.
December 20th.
I'm addressing Ms. Schooler. The worksheet that you're depending upon to justify your amount in your proposed journal entry, which is a couple $100 a month higher than what Mr. Wood's objection stated it should be. So where is your worksheet?
Your Honor, I believe because that wasn't a legal objection because you already had ordered for his income to be imputed. I didn't include it, but I am going to pull up my notes from the hearing that I have right here.
Well, that worksheet would need to be filed with the decree.
Right. Because you had already ordered for his income to be imputed.
True.
And
what the court often does, counsel, is to set the building blocks necessary to put the worksheet together. I hope to always settle those building blocks without determining the actual amount. That really is a mechanical computation. Once you know what to plug in, essentially the worksheet software does it from there. So I don't fault you in all respects here, Ms. Schooler. It's just that whatever worksheet is eventually generated based on the building block orders that this court has made, that needs to be included to support the child support amount, which is in the decree of divorce. But you're telling me that once you had adopted all the income numbers and put all the proper inputs in, it came out at $1,569 a month?
I do believe so, Your Honor, yes. I'm going to try to find it in what I sent to Mr. Wood.
And I may have adopted certain numbers out of a child support worksheet that had been submitted. But I think if there were any adjustments that needed to be made to the worksheet for any reason, tax exemption adjustments or anything, then I couldn't have settled or finalized the child support number at the hearing.
No,
That's why
you wouldn't have been able to,
requesting
Your Honor.
a transcript.
Because you will see in the my proposed journal entry, you specifically stated, and I'm going to find that paragraph for you, that his income must be imputed at that number because he had not provided any income information, and you felt that that was a good number for his trade skills, the kind of work that he does.
Imputed at what number?
$58,320.
That's what your child support worksheet says, but it says date submitted May 13th. The one you submitted on February 12th says 13,833, and on the child support worksheet the respondent submitted December 20th of 2023 states where we agree on no child support at all.
Well,
I'm
none of
all
those
for
past
taking
worksheets
care of
mean a
the
thing right
children.
now. What the court's concerned with was what was presented to the court at the trial and what numbers this court ordered be put into a child support worksheet to generate the eventual child support amount.
Your Honor, it's
I believe it was the one
Okay,
from February
just a minute, Mr.
12th.
Presbyl. Again, Ms. Schooler, you have the floor.
Paragraph 29 of my Exhibit A is where I reference you imputing the income, what you imputed at, and why you imputed it that way.
All right. Well, again, Ms. Schooler, it's just difficult for the court to adopt a worksheet number when I don't have the worksheet.
I do apologize about that.
But presupposing that you do have a proper child support worksheet, which places the numbers in that was found by this court to be appropriate at time of trial, if that's how it comes out, that's how it comes out. Now, what did you do with the tax exemption benefits, Ms. Schooler? What?
Your Honor,
What did
he
you
was
contemplate?
given a $203 credit because my client would have been able to claim all 3 children for the year 2024. There is also a daycare cost in the amount of $500 that my client pays. So father was imputed $500 for childcare, and then he was given a complete income tax credit for all 3 children.
Mm-hmm.
On the numbers per age on children, you have 2 children between the ages of 6 and 11 and 1 under the age of 5 or 0 to 5. Right now, at the time of this document, we have 2 ages 0 to 5 and 1 age 6 to 11. And where is the $500 child care? Where can I find that, Ms. Schooler?
Your Honor, do you want me to try to sort this out? I just don't want to.
Is it included on the proper line?
Yes, it's in paragraph G1 on the worksheet.
Okay.
And for the child support guidelines, when the child is over 6 months or close to 6 months, they
what you have
to the next age group. So I can't control that.
All right. I'm aware of that provision, counsel.
Your Honor, may I have time to file the past 2 years' taxes that a previous attorney told me to wait until this issue was resolved to file my taxes?
No.
Yes, sir.
We're settling today's journal entry based on what was presented and ruled upon at the trial of this matter.
I'm objecting to the journal entry being finalized today.
Next, we turn to the mother's lawyer, and her words hit differently. She carefully explains why she opposed the withdrawal, pointing out how the father's actions complicated everything. She underscores the strain between counsel, especially with threats of ethics complaints hanging in the air. What we see here isn't just legal maneuvering. It's a quiet reminder that reckless behavior in court has real consequences.
You can object all you want, but if the court determines that it can settle the journal entry today, it will.
This is a hearing for withdrawal.
We can't just hold up this decree indefinitely because you object to some of the rulings that the court made.
That's why I have requested it. That's why I'm getting the transcript.
What we're trying to do today is properly document the court's rulings. You can disagree with those, Mr. Presbyl.
That's what
you may even be able to take further legal action concerning them, But at this
Also-
juncture, we're just trying to settle the journal entry.
When it
And
comes
if-
to on the journal entry,
All right.
Miss
the child
Schuler
support
used a
worksheet.
fraudulent witness.
I'm going to tentatively adopt the language in the proposed decree because it is being represented by preparing counsel that she has properly used the numbers that the court ruled upon at the time of the hearing to formulate a worksheet. But without that worksheet before it, this court will reserve an eventual ruling until I see that worksheet as submitted in my queue with the decree. So, Ms. Schooler, it has to be with it.
Absolutely. I apologize. I just wasn't a legal objection, so I just didn't think. I thought we were going to resolve only that. So it will be submitted, of course.
Very well. So I'm going to overrule the general objection in number 8, purporting that I adopted some prior worksheet.
And Your Honor, I can read you my specific notes to you as to the income if you'd like to. Maybe that could jog your memory if you need that.
Well, I didn't attempt to send the child support number, correct?
I'm so sorry, Your Honor. He cut you off.
All right. I didn't attempt to adopt a specific child support number, as I recall.
No, Your Honor.
No, Your Honor.
It was subject to further computation and input into the worksheet.
Yes.
Yes.
So the court's going to overrule the objection to the child support worksheet at this time, pending this court's scrutiny of the eventual worksheet submitted to support the number. All right. Number 9. The court finds that the best record is kept by the Kansas Payment Center of systematic child support payments. I do understand the certain benefit that might accrue to Sydney if payments were made directly to her checking account. However, I think that it's important to keep an official public record of payments made. So I'm going to require that the general provision be followed and that payments may be made through the Kansas Payment Center in accord with what we do in the vast majority of all other cases. All right. Objection 10. Child support will terminate for each child after they complete their high school education pursuant to state statute.
Your Honor, I'm in the process of filing a motion and presenting documents to court. I really don't feel comfortable proceeding until the court has had a chance to review.
This is a turning point where the judge takes full control of the process. He announces he'll review the objections line by line, cutting through confusion and bringing the discussion back to the record. It's sharp, methodical, and signals to everyone that the courtroom won't be a playground for emotion. Every word shows us the judge's resolve to keep order and protect the integrity of the ruling.
Paragraph 35. Isn't that consistent with statutory language, Ms. Schooler?
Yeah, that's what my paragraph 35 says, just more in depth and cites the statute. So I didn't feel like that change would actually hurt the journal entry rather than.
I don't think that there's any inaccuracy there. I see no need for a change. Court will overrule objection number 10. Okay, number 11 does appear to raise a substantive issue here. Petitioner specifically indicates that the respondent was not awarded the 2003 GMC Sierra. Respondent was given a choice. If she wanted the Sierra, then she would have to take responsibility for the debt, or she could be granted the 2003 Chevy Silverado, and that she hadn't indicated her selection.
The Sierra is a business truck that I use on my taxes, and I was awarded everything regarding the business.
The paragraph's not identified, so where is that, Ms. Schooler?
So that is going to be paragraph 38 and 39.
Okay.
And Your Honor, in Exhibit B, the email where I sent the journal entry, parenting plan and child support worksheet to Mr. Wood, I note that there are a couple highlights within the journal entry because I need to be provided the documentation in regards to the Duramax, so my client can make a decision on which vehicle she wants. I have not received that documentation, and there was an objection about it, but I sent it with highlights saying I need this information, it's subject to change. Once I get the documents, I'll let you know her selection. I haven't received those documents, and this objection was filed.
I submitted all that documentation to my counsel. Let me find it.
All right. I don't see that the 2003 GMC Sierra is addressed in either paragraph. Is that what you're? There are a lot of vehicles involved here, but I don't see a specific reference to a 2003 GMC Sierra.
I think she called it a GMC Duramax.
So I believe it's between the Chevy Silverado and then the GMC Duramax are the two options my client can pick. I think there's one in each paragraph for the time being, but when I submitted those to Mr. Wood, there were highlights on them because I don't know where to put each one yet because she hasn't made a decision because she hasn't received the documentation.
Bottom line is, I was awarded all the property in B&B Construction Services, and that vehicle is used for tax purposes. And you have manipulated the court's ruling, Ms. Schuler. The transcript will prove that. In the
All right. So
notice
Ms.
of
Mueller, I trust that the court ordered that she had some sort of choice she could make, and she hasn't made the choice?
Because there's debt tied to one of the vehicles, and you said if you pick this car, you have to take the debt, but I need the documentation reflecting the debt, and I don't have that. So she can't decide because maybe it's a significant debt. We don't know.
10,000 and something. I submitted that to my counsel. I got a pile of paperwork here. I'm trying to find it.
Mr. Wood, do you have that documentation as to how much this debt is on the GMC Sierra?
And not other than what I put in there, the amount of $10,024.20. But
Where did you get that?
I'm sure I got it off the documentation, but I can look for that, Your Honor. I just don't know that I have it with me right now, but I can send that to him.
If that's the amount of the debt, what would your client's election be then?
I believe she would want to take the vehicle. Is that correct, Ms. Simon?
Yes.
Even though it has that kind of debt on it?
Yes.
Okay.
But I just obviously would like to do my due diligence and verify the debt amount. So that's why I was not able to make a selection.
What does it say regarding me being awarded property when it comes to B&B Construction Services? Can you state that, Ms. Schuler?
I'm waiting for Chief Judge Ricky.
All right.
That's getting a little off.
I hate to make you resort to this, but apparently Howard State Bank would be the creditor. May take a business record subpoena, but I think Mr. Wood, if he's got it, he'll turn it over, and the court will so direct whether he's allowed to withdraw at the end of this hearing or not. It's just a document in his possession that I believe should be turned over.
I'll look for it, Your Honor, and see if I can find it. If I have it, I'll send it to Ms. Hoover.
That's a very specific number that you stated, Mr. Wood, so I trust that you had some documentation supporting that very specific number.
I guess we could put in the journal entry that, I mean, she'll take that contingent on the debt being that amount, and or we'll get the records.
Not to exceed that amount. Yeah.
Yeah, not to exceed that amount.
Yeah. Mm-hmm.
Will the court take notice that Mr. Woods filed a fraudulent claim for his motion to withdraw? And I'm going to prove it. I have audio and a transcript of it.
Well,